say virtually we come to a 50% of that. That is the part 4 on charge and discharge. And to understand these aspects from none other than Justice V. Kumar, who I can say has become an epitome on sharing his knowledge on different pedestals. Before going live, I was talking to him that live law, beyond law, anything in and around with law, and especially on the criminal aspects. We have Justice Kumar. So he was saying that we will take different sessions on different aspects. The part on will is also doing tremendously well. But since there are vacations coming around in certain places, and like we have the places out here for the Dussehra break, without taking much time, not to spoil the festive mood, but the festivity of understanding the law would continue to be there. The firecrackers of knowledge will continue as long as we have from people like Justice Kumar. And I'll say Justice Kumar to take the baton, his usual style of making us understand. And then we will take those questions. We have shared it on the platform amongst the groups. Those who want, beyond those questions also, we will take happily those questions. Over to you, sir.
Thank you. Good afternoon, friends. Before going into sections 212, 213, 214, etc., I will make a quick recap of the topic covered during the previous lecture. We saw what a charge is and what is the necessity for a written charge. We also noticed that the charge was to be framed by the court and not by the police or by the investigating agency, and that the charge should be in the language of the court. We also saw that if the accused does not know the language of the court, because charge has to be framed by the court in its own language, in the language fixed by the state government. But supposing the accused doesn't know the language of the court, then even though the charge is to be framed in the language of the court, the judge, presiding judge, is to explain to the accused the entire charge in the language known to him. And it should be read over and explained to him so that he can effectively plead guilty or not guilty. He is free to plead guilty. He is free to plead not guilty also. So in order to give him the right to plead guilty or not guilty, the charge should be read over in his own language, in the language known to him, and explained to him, so that he gets an opportunity to plead guilty or not guilty. We then explored the ambit of section 211 CrPC as to the contents of the charge. We noted that model charges are available in form number 32 of the second schedule to the CrPC. We noted that if there was a previous conviction to be proved against the accused, this aspect should not enter the mind of the trial judge unless and until a conviction is recorded in the case on trial. This is only thereafter, only after recording a conviction, can the court consider the question of previous conviction. In fact, the investigating agency and the prosecuting agency should not bring it to the notice of the court that the accused facing trial has a previous conviction to his discredit. Once that enters the mind, there is every likelihood of the judge getting prejudiced. That is why they should not enter the mind of the court unless and until he convicts the accused in that case on trial. Then thereafter, a separate charge for previous conviction is to be framed and he should be asked to plead guilty or not guilty. I told you that for saving time, supposing it may be a case where instead of passing a sentence, even if the court is convicting him, even if the court is finding him guilty, instead of passing a sentence at once, court can extend the benevolent provisions of the Probation of Offenders Act. Formerly, it was section 360 CrPC. Now, with the extension of the Probation of Offenders Act 1958 to the states, all the states it has been extended to all the states, including Kerala, Madhya Pradesh, all those states. Once that act is extended to the state, then 360 CrPC has no application. And then, if it is a case where the accused is to be given the benefit of probation, then the court has to call for the report of the probation officer. There's a government servant called probation officer who has complete history about the antecedents, all other whereabouts of the accused. But if you once you convict the accused and then ask for his report, it will further delay the final disposal of the case. Therefore, in order to obviate the delay, we in Kerala, we have been advising our judicial officers to get the report of the probation officer in a sealed cover in advance. Get it in a sealed cover. Don't open it until you convict the accused. In case you are convicting the accused, then you can open the sealed cover and see whether what are his antecedents. If it is a fit case where he could be released on probation, or he could be given admonition under the Probation of Offenders Act without any, there is no stigma attached. If he is released on probation or if he is admonition given, then there is no stigma. Stigma of a conviction will not be there. Act is specifically says so. Then in that case, you can open the sealed cover, look at his antecedents and decide accordingly. We noted in case the accused is convicted, the trial judge can open the sealed cover and then decide on that. We noted the desirability of framing independent charge for murder in each of the on each of the members of an unlawful assembly falling under section 149 of the Indian Penal Code. We saw the distinction between section 34 IPC and section 149 of the IPC. Both are provisions for fixing vicarious liability on or constructive liability on the accused. The main distinction is while section 34 is not a penal section, you can't have a conviction under section 34. Section 149 is a penal section. You can have a conviction. Only thing is the punishment will be according to the punishment to be awarded in the main offense. And if he is a member of an unlawful assembly, we have seen that each member will be liable even if he has not done anything. If he had shared the common object of the unlawful assembly, and if any one of the members of the unlawful assembly alone did the crime, every other member will be deemed to have done the same act, and law will find him guilty of the same offense. But the conditions are he should be a member of an unlawful assembly, for which there should be minimum 5, and he should have shared the common object of that assembly. Supposing all the 5 persons were going to give a beating to the victim, they were fed up with the victim. He was a constant troubleshooter. So they decide, we'll give him a beating. They go with sticks and all of them go there. So that was the common object of the assembly. But supposing one out of them take out a knife from his waist and gives him a deadly stab. He is administering a deadly stab, whereby he dies. Then you can't say that the other members shared the same common object. They shared the common object of giving him a beating only. Therefore, they cannot be convicted for murder. That's the distinction between 149, the main gist of section 149. Whereas in the case of section 30, here under section 149, all of them need not be participants. All of them need not participate in the action. Even if one is participating, that is enough if all the others share the same common object. But in the case of section 34, we saw that all of them have it is in furtherance of a common intention. That common intention means there should be a pre-concerted meeting. There should be a pre-concerted meeting, and every one of them should have the same common intention. Therefore, and he will be presumed to have participated in the occurrence. Every member of the assembly falling under section 34 will be presumed to have committed the same offense. Because he had the intention, common intention. The distinction we beautifully saw in William Slaney's case, year 1956, Supreme Court 116, Constitution Bench, beautiful judgment by 3 of the judges, giving concurring judgments. Now today, we will try to explore the contours of sections 212 to 214, 212, 213, and 214 of CrPC. Now, can anybody read section 212? Section 212. We have section 212 CrPC. You are not, you cannot be heard, Vikas. Please unmute. You are muted.
Yeah, no, I mute myself because it's an office and a lot of buzz goes around. Do I read section 212?
Yes, 212.
Yeah. 212, particulars as to time, place, and person. As Justice Kumar had previously explained, the details have to be explained in the extenso. First, 212, the charge shall contain such particulars as to the time and place of the alleged offense, and the person, if any, against whom, or the time, if any, in respect of which it was committed, as are reasonably sufficient to give the accused notice of the matter with which he is charged. 212, subclause 2, when the accused is charged with a criminal breach of trust or dishonest misappropriation of money or other movable property, it shall be sufficient to specify the gross sum, or as the case may be described, the movable property in respect of which the offense is alleged to have been committed, and the dates between the offenses alleged to have been committed, without specifying the particular items or exact dates, and the charge so framed shall be deemed to be a charge of one offense within the meaning of section 219, provided that the time included between the first and last of such dates shall not exceed 1 year.
Yes. So 212 clause 1 says, the court charge shall contain such particulars as to the time, place of the alleged offense, the person, if any, against whom the thing was committed, and the person who committed the offending act. These things should be necessarily there in the court charge, so that court is also having a direction as to how the trial should be conducted. More than that, the accused is informed of the case he has to meet, of the case he has to defend. That is the purpose of subsection 1 of section 212. Now, the principle of section 212 CrPC is that the normal rule with respect to framing of charge is that there should be a charge for each distinct offense, and every such charge should be tried separately, not one single trial, separately, as provided under section 218 1 CrPC. In fact, there's a beautiful judgment by recent judgment, very nascent judgment by Justice Chatrath on behalf of 3 judges of the Supreme Court in Naseeb Singh versus State of Punjab. We will have occasion to discuss that judgment in detail when we discuss section 218. The main rule, the rule under section 218(1) is that there should be a charge for each distinct offense, and every such charge should be tried separately as provided under section 218 clause 1 CrPC. Section 212(1) CrPC mentions what the contents of the charge should be. Subsection 2 of section 212 is an exception to the normal rule. Normal rule is there should be a separate charge for each distinct offense, and each charge should be tried separately. 212 clause 2 is an exception to this normal rule to meet certain contingency with respect to framing of charge in cases of criminal breach of trust and dishonest misappropriation of property, etc. It's only when it may not be possible to specify exactly the particular items with which, with respect to which the criminal breach of trust took place, because it is all done in secrecy. So you won't be able to know on what all dates these offenses were committed, and slow or misappropriation or dishonest misappropriation of property. A public servant having his office, he may be doing it on several days, on several occasions. There may be several instances even on single days. So it may not be possible for the outsiders or even the office, those who are in charge of the office, to find out on which all dates he committed those offenses. Therefore, subsection 2 is in the form of a proviso to the main rule under section 212(1), that if it is a criminal breach of trust or dishonest misappropriation of property, it is only when it is not possible to specify the particular items with respect to which the criminal breach of trust took place, or the exact dates on which the individual items were misappropriated, etc., that the court is given the authority to lump up the various items with respect to which the criminal breach of trust was committed and to mention in the charge the total amount misappropriated. It is not necessary that the court should, in the charge, mention that on such and such day you misappropriated this much amount. Court need not have a breakup of the misappropriation. It can be lumped up by the court within a year. Total misappropriation within a year. If the charge is so framed, it shall be deemed to be a charge for one offence. It was beautifully explained by the Supreme Court in paragraph 14 of Ranchod Lal versus State of Madhya Pradesh. AR 1965 Supreme Court 1248. 65 Supreme Court 1248. Great judges K. Subbarao, Raghubar Dayal and Rajagopal Iyengar. K. Subbarao, Raghubar Dayal and Rajagopal Iyengar. The judgment pronounced by Raghubar Dayal. Now, shall we go to the questions on section 212?
Yes, sir. So what are the principles which can be discerned from section 212, 215 and 464 of CrPC?
There's a beautiful judgment giving the total application of these three sections. The principles are: one, the object of framing charge is to enable the accused to have a fair or clear idea of what he is being tried for and of the essential facts that he has to meet. The charge must also contain the particulars of the date, time, place, and person against whom the offence was committed, as are reasonably sufficient to give the accused notice of the matter with which he is charged. This is the purpose of section 200. This is the gist of section 212, clause 1. Then the accused, second rule. The accused is entitled to know with certainty and accuracy the exact nature of the charge against him. And unless he has such knowledge, his defense will be prejudiced. When an accused is charged with having committed an offense against one person, but on the evidence led, he is convicted for committing an offense against another person, without a charge being framed in respect of that allegation, the accused will be prejudiced, resulting in failure of justice. Accused is told that he committed murder of A, but the evidence adduced shows that he committed murder of B. He was never told that he committed murder of B. Therefore, when evidence is adduced to show a different person was the victim of the offense, naturally the defense of the accused will be prejudiced, because he is only called upon to answer the court charge. Court charge says he committed murder of A, but the evidence is he committed murder of B. Totally different person. So he will be naturally prejudiced, resulting in failure of justice. But there will be no prejudice or failure of justice where there was an error in the charge and the accused was aware of the error. Supposing during the trial and during the cross-examination of the prosecution witnesses, his suggestions are that, is it not correct that the court charge is such and such, and I am being called upon to answer this charge? Supposing even at the commencement of the trial, he was aware that there is a mistake in the charge, but he was very much aware that he has to face not the court charge as framed, but against a person which according to because there will be the police charge sheet. There will be the charge sheet of the police showing the correct person. There is only a mistake in the court charge. Only in the court charge there is a mistake committed. Therefore, even if that court charge is false, or there is a mistake in the court charge, if during trial the defense of the accused is such that he is really aware of what he has to face or what he has to meet, then you can't say that he has suffered any prejudice. Such knowledge can be inferred from the defense. That is, the defense of the accused should show that he was defending himself against the real and actual charge and not the erroneous charge. He was really defending the real charge and not the erroneous court charge. Real charge means the police charge is there, charge sheet is there, the prosecution materials are there, all the prosecution evidence has been given to him, copies have been furnished to him. All those show that the murder committed was of B, not A. But wrongly the court charge says A. But he knows that the police charge says B. He knows that all the evidence adduced by the prosecution, all the material copies of documents given to him shows that the victim was B, not A. So it is only a mistake in the code, and a sort of what should I say, just oversight, just an oversight by the court while framing the charge. He cannot, in such a situation, take advantage of the court charge and tell the court that no, I was not called upon to meet this charge. I have been called upon to meet that the charge that I committed murder of A. Now you are adducing evidence to show that I committed murder of B. When his evidence, the manner in which he shaped his evidence, he said that he knew very well that he was called upon to answer a charge that against the correct person. Then he cannot take advantage of the mistake in the court charge. There will be no prejudice. There will be no failure of justice. In judging a question of prejudice as of guilt, the court must act with a broad vision and look to the substance and not to the technicalities. And their main concern should be to see whether the accused had a fair trial, whether he knew what he was being tried for, whether the main facts ought to be established against him were explained to him fairly and clearly, and whether he was given a full and fair chance to defend himself. All this was the proposition laid down beautifully in Mainpal versus State of Haryana, AR 2010, AR 2010 Supreme Court 3292, AR 2010 Supreme Court 3292. We pass on to question number 2.
It is as good as in civil law once they say that vague charge will not prevail, even in disciplinary proceedings. And number 2, they say that even if a wrong section is provided, but the patent substance could be gathered from what it intended.
Exactly.
The law, even in the civil law, is to the effect that the wrong mentioning of the sanction would not do. Ultimately, the tone and tenor of the charge would express it.
Just because a provision is misquoted, that is of no consequence.
Question number 2, supposing there is a contravention of an order made under Section 3 of the Essential Commodities Act 1955 by a company, who are the persons liable to be prosecuted for the offense in such a case?
When a company commits an offense, when an offense is committed by a company, the persons who are liable to be prosecuted are first the company itself, which is a juristic person. Then any person who at the time of contravention was committed was in charge of and was responsible to the company for the conduct of business of the company. At the time of contravention, every person who was in charge of and responsible to the company for the contravention, for the conduct of business of the company, he will also be liable apart from the company. Then any director, manager, secretary or other officer of the company with whose consent or connivance the neglect or consent, connivance or neglect the offense was committed, such persons will also be responsible, liable in the eye of law. Beautifully stated by Supreme Court in State of Punjab versus Kasturi Lal, AR 2004 Supreme Court 4087, AR 2004 Supreme Court 4087. Now, even if the company being a juristic person cannot be punished by passing a sentence of imprisonment, because company is a juristic person, it cannot be imprisoned, but the other persons can be punished by imprisonment. ANZ Greenlace Bank Limited, Directorate of Enforcement, 2004, Volume 6 SCC 531, 2004, Volume 6 SCC 531. 3 judges, Justice Santosh Hegde, S.B. Sinha and A.K. Mathur. 3 judges. Question number 3. You are not audible. You are muted.
Yeah.
Again muted.
Where acts of criminal breach of trust in respect of different amounts of money punishable under Section 409 IPC were committed within 3 and odd months, and all the acts were committed in the course of the same transaction, is separate trial illegal in such a case?
We have already seen the rule under Section 218 is a separate charge for separate offense. and separate trial for separate charge. Therefore, that is the rule. If that rule is strictly adhered to, you can't say that it is wrong. Though, for the sake of convenience, if it was committed in the same transaction, as part of the same transaction, courts can rely on section 219 or section 220 CrPC and have the trial on single trial. But just because the main rule is adhered to, main rule under section 218(1) is adhered to, you can't say that trial is illegal. That is what the Supreme Court said in Ranchod Lal versus State of Madhya Pradesh, AR 1965, Supreme Court, 1248. Because for separate trial for each charge is the rule under section 218(1). Therefore, if that rule is strictly adhered to in a case, you can't find the court, find fault with the court. But very often, if it is done, committed in the course of the same transaction, we have another rule to bang upon. The court has got another rule to bang upon. The court will try all the offences together on single joint trial. But just because the main rule is adhered to, you can't say that the court is wrong. Ranchod Lal versus State of Madhya Pradesh, AR 1965, Supreme Court, 1248. Again, 3 judges. I have already given the citation. Justice K. Subbarao, Raghubar Dayal, and Rajagopal Iyengar. Judgment, author of the judgment is Raghubar Dayal. Question number 4. You can remain unmuted.
Where are the charges? Where the charge was for criminal breach of trust in respect of a gross sum of money embezzled within the period from 6th of March 1949 to 30th of June 1950, that is around a period exceeding 1 year, has not the charge contravened the proviso of section 222 subclause 2 of Old Code corresponding to section 212 subclause 2 of CrPC and section 334 of Old Code corresponding to section 219 of the present code, so as to vitiate the trial?
Both these sections say that these offences can be tried. Only those offences which were committed during the course of 12 months, 1 whole year, 12 months alone can be tried in one trial. The rest of the offences will have to be tried in the next year. Likewise, otherwise it will amount to prejudice for the accused. That is the purpose of this section. But the Supreme Court in State of Bombay versus Kumar Sahib, Buran Sahib, Inamdar, AR 1962, Supreme Court, 1153. Again, 3 judges, S.K. Das, K. Subbarao, and Raghubar Dayal. Judgment by Justice Raghubar Dayal held that just because this 1 year rule, 12 month rule is violated, you can't say that it is illegal and it will prejudice the accused or that it will vitiate the trial. Because as the charge could have been split up into 2 charges in respect of the 2 periods, they could have been tried together. Therefore, it will not result in illegality. Incurable, it is not an incurable illegality, is the finding by the 3 judges bench. But here we have to take note of one aspect. The violation actually amounted to an illegality as was held by the Privy Council in N.A. Subramania Iyer versus Emperor, ILR 25 Madras 61, Privy Council, which in turn was approved in paragraph 9 by the judgment of Vivian Bose in Williams Lani versus State of Madhya Pradesh, AR 1956, Supreme Court 116, Constitution Bench. Constitution Bench having approved this Subramania Iyer's case in Privy Council, where the Privy Council said that it is not a mere irregularity, but it is an illegality, which is not curable under section 465 of the present code. Then the 3-judge bench was actually going against the Privy Council as well as Constitution Bench in Williams Lani's case. But in fact, in this ruling, 62 Supreme Court, AR 1962 Supreme Court 1153, the judges did not refer to this Subramania Iyer or Williams Lani. which are binding precedents on the point, exactly on the point. On the contrary, the decisions which were referred to were Pulikuri Kottayya, AR 1947, Privy Council 67, and Abdul Rahman versus Emperor, AR 1927, Privy Council 44. In fact, in Pulikuri Kottayya, the facts are different. In Pulikuri Kottayya, the 161 statement of the witnesses interrogated by the police officer were not made available to the accused. So, Pulikuri Kottayya said non-supply of 161 statement itself is prejudice. But then, in that case, there was another situation. Though the sub-inspector did not make available the statement, the circle inspector had conducted an investigation. He had overseen the investigation by the sub-inspector. And he had furnished the statements to the accused. Therefore, Pulikuri Kottayya, the Privy Council held that though failure to supply the 161 statements of witnesses is an incurable illegality, in this case, there was no such failure. Therefore, the accused cannot take advantage of that. That is Pulikuri Kottayya. In fact, Pulikuri Kottayya is more famous in the matter of confession. We have seen Pulikuri Kottayya being cited by every webinar lecturer on speaking on confession. Because that is a case where the contours of section 27 of the Evidence Act were beautifully explained by the Privy Council. Then Abdul Rahman versus Emperor, AR 1927, Privy Council 44. There the violation was the deposition of the witnesses were not read over in the presence of the accused and his counsel. The deposition of witnesses were not read over in the presence of the accused and the witnesses and the accused and his counsel, as mandated under section 22, clause 2 of old code, corresponding to section 278 of the present code. 278.1, I'm sorry, it was section 360. Section 360 of the old code said that whenever the evidence of witness has been recorded, the deposition shall be read over to the witness in the presence of the accused and his counsel. You have a corresponding section 278.1 of the present CrPC. That was the violation there. There the Supreme Court, the Privy Council very correctly said that it is only a curable irregularity. The deposition itself was taken in the presence of the accused and his counsel. Therefore, just because it is not read over in the presence of the accused and his counsel, you can't say that the trial is vitiated. My respectful view is that Subramania Iyer lays down, of course, Subramania Iyer lays down too harsh a principle. It lays down too harsh a principle. Just because some of the offences cross just beyond 12 months, can you say that it will vitiate the trial? As was held in Subramania, too harsh a principle. On principle, I am inclined to accept the 3-judge bench Supreme Court decision. But then what is regrettable is judicial indiscipline of the Supreme Court in benches of lesser quorum strength, going against binding verdicts of larger quorum strength without a reference to a larger bench and asking for authoritative verdicts. Supposing there is a binding decision by a 3-judge bench or a 5-judge bench or a 7-judge bench, then a 3-judge bench or a 2-judge bench cannot bypass that binding decision and lay down its own decision, contrary to the binding decision. The proper way of doing it is to refer it to a larger bench and get an authoritative decision so that the larger bench can overrule the binding decision which may be laying down incorrect law, which may not be laying down the correct law. That is the principle of stare decisis. That principle has been violated, even though I am in full agreement with the view taken by the 3-judge bench that just because the period of 12 months is violated, it does not vitiate the trial. I fully agree with in fact, even though the 3-judge bench did not refer to N.A. Subramania Iyer's case of the Privy Council, that Subramania Iyer was binding precedent and approved in 5-judges bench of William Slaney's case, Constitution bench. That's the Bible. That's the leading case on defect, omission, defect, illegality, irregularity, etc. in charge, court charge. and that they approved. Justice Vivian Bose had approved this Subramanian's decision. So it was not permissible for a three-judge bench to go against that. The proper way was to get it to refer to a larger bench for a more authoritative pronouncement. Anyway, that I am only making a reference to that. Though on principle, I am in full agreement with the three-judge bench's view that just because some of the offences crossed 12 months, you just can't call it an illegal, an incurable illegality, so as to vitiate the trial. It will not vitiate the trial, according to me. But Subramanian Iyer and William Slaney will stare at every judge. Yes. Question 5.
In section 212 CrPC, an enabling provision for the prosecution to put in a gross sum of money representing the total amount misappropriated by the accused.
Yes.
As I stand corrected, I missed the word.
Yes, it is. Instead of framing a large number of separate charges in respect of small sums of money, which go to make up a gross amount, section 212(2), clause 2 of section 212 enables the prosecution to put in a gross amount as aforesaid. I have read it. We were reading the section. Subsection 2 enables the court to put the entire gross amount instead of giving driblets of the amounts. This is what the Supreme Court held in Ranchot Lal versus State of Madhya Pradesh, AR 1965 Supreme Court 1248. 65 Supreme Court 1248. I already given you citation. And there's an Andhra Pradesh ruling also, AR 1959 Andhra Pradesh 520. 59 Andhra Pradesh 520, corresponding to 1959 Criminal Law Journal 1138 Andhra Pradesh. Question number 6.
Like you were speaking, we have also seen there was a judgment after the judgment of Uma Devi in service matters, wherein they said regularization. Then the two judges said that they have not considered the judgment of Maneka Gandhi. Thereafter, it was said you cannot say that the 5 judges have not considered the 2 judges. The equal strength will do. And thereafter, we had that judgment of the reserved category candidates.
Yes. 2 judges bench.
Of Jarnail Singhs.
You're right. Verdict of 2 judges is not binding on a constitutional bench of 5 judges. But the converse is true. A verdict of 5 judges is binding on 2 judges.
Is not the charge under section 376 IPC specifying a period of 5 to 6 days as approximate invalid?
There, the alleged rape was committed within 5 or 6 days. The exact number of days or the exact dates were not mentioned in the court charge. So it was argued before the Supreme Court that when the court charge the CrPC insists on time, date, everything in the court charge. Here's a case where the rape was committed within 5 or 6 days approximately. So that approximation in the court charge is invalid. So I was prejudiced in my defense. That was the argument raised before the Supreme Court. Supreme Court said the last limb of section 212(2) allows such a charge. That was the decision in Chittaranjan Das versus State of West Bengal, AR 1963 Supreme Court 1963. But I have again my own reservations about this judgment. The subsection 2 of section 167 of 212, subsection 2 has nothing to do with rape and other offences. Subsection 2 says, when the accused is charged with criminal breach of trust or dishonest misappropriation of money or other movable property, it shall be sufficient to specify the gross sum, as the case may be, the describe the movable property in respect of which the offence was committed, or the particular items or the exact date need not be mentioned. It applies, subsection 2 of section 212 applies only to criminal breach of trust and dishonest misappropriation of property only. This is a case of rape where it is not possible to mention approximately it was committed within 5 or 6 days from such and such date. That may not be in fact, instead of relying on subsection 2, the court should have said that in fact time, the particulars as to time as reasonably, section 212(1), clause 1 of section 212 says, as may be reasonably sufficient to give the accused notice of the matter with which he is charged. Time. Time, in fact, under the CrPC, under the law, CrPC as well as General Clauses Act, date is included in time. Time includes date. That is why Section 9 of the General Clauses Act 1897 indicate that the word time includes day. Because while computing the commencement and termination of time, the days are included. So time, the expression time includes date. Therefore, as is reasonably sufficient to give the accused the notice of the matter with which he is charged. That could have been the explanation, justification given by the court to explain the so-called defect in the court charge instead of relying on subsection 2. Subsection 2 has no application. Subsection 2 of section 212 has application only to criminal breach of trust and dishonest misappropriation of property only, no other offense. So the justification placed, reliance placed on subsection 2 section 212 was, according to me, with due respect, not quite correct. It could have been brought under section 212(1), clause 1 itself. Yes. I gave this citation only to make you understand that don't go by subsection 2 of section 212. We are on section 212. Don't go by section 212 to explain any defect in the court charge with regard to offences other than criminal breach of trust and dishonest misappropriation of property. Yes.
Is there any clear distinction between the provisions which prescribe the manner of trial and the provisions which provide for the conduct of trial?
The manner of trial and the provisions relating to conduct of trial. An infringement of a provision as to the manner of trial cannot be cured by recourse to section 465 CrPC. It's an incurable defect. If it results in an illegality in the conduct of trial, which was not according to the manner prescribed. If the trial was not according to the manner prescribed, then it is an illegality which is not curable under section 465 CrPC. Where the charges were spread over a period of exceeding 1 year and the trial was conducted in violation of section 234 of the old code corresponding to section 219 clause 1 of the present code, it was held that it was not a mere irregularity but an illegality which could not be cured under section 537 of the old code corresponding to section 465 of the present code. That is the ruling in N.A. Subramania Iyer, which was affirmed. That is, citation is ILR 25 Madras 61. ILR 25 Madras 61 Privy Council. That was the ruling which found its approval in the hands of Justice Vivian Bose, speaking for the Constitutional Bench in William Slaney's case. We had in fact, this Subramania Iyer refers to, this Privy Council refers to Taylor versus Taylor, 1875, 1 Chancery Division 426 at 431. The Judicial Committee of the Privy Council, that was referred to, in fact, not in Subramania Iyer, but in the subsequent ruling, Nazir Ahmad versus King Emperor. In Nazir Ahmad versus King Emperor, year 1936, Privy Council 253, it was Taylor versus Taylor was relied on to say that when a statutory power is conferred for the first time upon a court and the mode of exercising that power is pointed out, it means that no other mode is adopted, can be adopted. When the mode of exercising a particular statutory power is prescribed by statute on a court, no other mode can be adopted. No other mode can be adopted. This was referred to at the end of para 8 in AIR 1960 Supreme Court 801. Again, 5 judges. BP Sinha, Chief Justice, S.J. Imam, A.K. Sarkar, who is the author of the judgment, and K.N. Wanchu and J.C. Shah. They were the judges. Another constitutional bench which approved Taylor versus Taylor and Nazir Ahmad versus King Emperor. You may also refer to Umar Sahib, Burra Sahib, Inamdar versus State, year 1960, Bombay 205, beautifully stated by the Bombay High Court. Then in AR 1960 Supreme Court 661, AR 1960 Supreme Court 661, Kadiri Kunyamad versus State of Madras. This is a case from Kerala. where it is held that if the criminal trial is conducted substantially in the manner prescribed by the code, by the CrPC, but some irregularity occurs in the course of such trial, the irregularity can be cured under the old section 537 CrPC corresponding to section 465 of the present code. So if the trial has been conducted substantially in accordance with the manner prescribed by the code, by the CrPC, and there is some irregularity committed somewhere, that irregularity can be cured. You cannot say that the entire trial is vitiated. It's a good principle. Abdul Rahman, AR 1927 Privy Council 44 was lied on. Yes. Pass on to question number 8.
7 we have done. Manner and conduct.
No, question 8.
Yeah. Where there was already a trial in respect of a gross sum alleged to have been embezzled between two specific dates, can there be a second trial in respect of another sum embezzled on an intermediate date, but not included in the gross sum for which the earlier charge was framed?
Referring to section 212, we said that if clause 2 of section 212, we saw that in the case of criminal breach of trust and dishonest misappropriation of property, it is enough that the two outer dates are mentioned and a lump sum amount is mentioned. Take a case where there is a specific misappropriation in between on a particular date, which was omitted to be mentioned in the earlier charge, in the lump sum charge. Can it be then put against the accused in a second trial? He will say that no, I was already tried for the greater. There is a trial for misappropriation, and the outer date, both the first date and the last date were mentioned, and it was all I was already tried. Now you cannot try me for a particular item of evidence which was omitted in the earlier trial. If there is an explanation or justification given for the omission in the earlier trial, he can be tried again. This is what the Supreme Court, the Patna High Court, there's no Supreme Court on this. The Patna High Court held in Chittaranjan Saha versus State, AR 1960 Patna 168. If there is an explanation or justification given for the non-inclusion of this particular item in the earlier trial, which was an omnibus trial for the entire property and for the entire period, if there is a justification, it can be discerned from the earlier trial also that this particular item was not included, and it can be explained by the prosecution. A separate trial for this item alone can be had, what the Patna High Court held. Question number 9.
Even though the recitals in the charge have stated that the main object of the criminal conspiracy was cheating by impersonation, in the charge under section 419 IPC, there is no specific mention of cheating by personation, punishable under section 417. Is not the accused justified in contending that he was charged for cheating simpliciter?
He was charged for cheating only, but the charge said that the manner of cheating was cheating by impersonation. He had impersonated somebody and he had cheated somebody. But the charge only mentioned the cheating only. Charge mentioned only cheating. There is no specific charge for cheating by impersonation punishable under section 417. 417 IPC was not in the charge, but charge also mentioned that you committed cheating by impersonation. So the accused said that no, I was not charged for cheating by impersonation. The charge is only cheating. Court said nothing. Supreme Court said nothing doing. Though charged specifically for not for 417 of the Indian Penal Code, the court charge also mentioned, explained that you had committed cheating by impersonation. Therefore, you can be convicted under section 417 Indian Penal Code. AIR 1977 Supreme Court 2433. AIR 1977 Supreme Court 2433. Yashpal Mittal versus State of Punjab. 3 judges. Yashpal Mittal versus State of Punjab. Now, with that, we pass on to the next section, section 213.
Yes, sir. Section 213, when manner of committing the offence must be stated. When the nature of case is such that the particulars mentioned in section 211 and 212 do not give the accused sufficient notice of the matter with which he is charged, the charge shall contain such particulars of the manner as which the alleged offence was committed, as will be sufficient for that purpose. Illustrations. A is accused of theft of a certain article at a certain time and place. The charge need not set out the manner in which the theft was effected. A is accused of cheating B at a given time and place. The charge must set out the manner in which A cheated B. A is accused of giving false evidence at a given time and place. The charge must set out that the portion of the evidence given by A which is alleged to be false. A is accused of obstructing B, a public servant, in the discharge of his public functions at a given time and place. The charge must set out the manner in which A obstructed B in the discharge of the function. E. A is accused of murder of B at a given time and place. The charge need not state the manner in which A murdered B. F. A is accused of disobeying a direction of the law with the intent to save B from punishment. The charge must set out the disobedience charged and the law infringed.
While discussing section 211, we said that there are certain named offences like murder, criminal conspiracy, or some named offences are there. When rape, when the named offences are there, the court charge need not explain or need not elaborate on the way in which the murder was committed or the way in which the rape was committed. It is enough that the ingredients of the rape as defined or the ingredients of murder as defined are present. When the court says you committed murder of somebody, you committed rape of somebody, but there are certain other offences like cheating. It is not enough that the court charge merely says you committed cheating. What way? How did you cheat? What was the modus operandi adopted? What was the manner in which the cheating was done? By merely saying that you cheated somebody, you cannot say that and especially there may be cases where he might have cheated so many people and so many transactions. So he should be specifically told that you committed cheating of somebody in respect of this particular transaction or in respect of these 5 transactions. Otherwise, he will be prejudiced in his defense. That is the purpose of this section. The illustrations are very clear. We will pass on to the questions. Question number 1 on section 313. You are again muted.
If the accused knows what the case against him is and all the details of the offense and the incident are indicated in the charge, is it not permissible to infer prejudice in the trial?
We have already seen. If all the ingredients court charge, then he cannot put forward a plea of prejudice and try to get an acquittal. No such inference can be made. That is elaborating on the William Slaney's case, AR 1956, Supreme Court 116. 3 learned judges had given in 3 separate, independent, concurring judgments in that case. AR 1956, Supreme Court 116. 5 judges altogether. Yes.
Where the charge says that the accused forged a nikah form, a valuable security, in relation to his marriage with one Syrian Bhai and thereafter committed an offence punishable under section 467 IPC. Can it be said that the charge is vague merely because the charge does not mention the circumstances under which the document was allegedly forged?
Yes. It only says that you commit an offence of forging a nikah form, a marriage form, which is a valuable security. That is not enough. In what way it was forged? The forgery, in what way the forgery was committed, so as to put him on notice. Then the manner in which the forgery was committed should be told. He should be told. The Supreme Court held that this was not enough. It had no, and that was a special case where even no oral evidence was adduced. Oral evidence was also not adduced. Supreme Court said the charge itself was defective. Over and above that, no oral evidence was also adduced by the so-called victim. Therefore, the accused was acquitted. Hassan Ali versus State of Madhya Pradesh, AR 1983, Supreme Court 352. Year 1983 Supreme Court 352. Question 3.
The accused is charged with the offense of cheating 1 George. The manner in which the accused cheated George is not set out in the charge. There are many transactions between the accused and George, and the accused had no means of knowing as to which of the transactions did the charge referred. Accused therefore offered no defense. Is the charge framed in contravention of section 213 CrPC?
Yes, I have already explained to you. There were so many transactions between the two, accused and George. The charge only says you cheated George. Which transaction? What was the amount involved? On what all dates, time, etc. Silent. That's the vaguest of a charge. There cannot be a more vague charge than this, such a charge. So that's on such a charge, the accused is called upon to defend himself. He will be prejudiced in his defense. Therefore, in fact, this is covered by illustration C to section 215. Illustration C to section 215 of CrPC is same question. We pass on to question number 214. Of course, I know that framing of charge is a very dry subject. It's not as interesting as murder or culpable homicide, murder, not amounting to murder or murder, or other or contradiction, corroboration, all those things. They are very interesting. But this is a very dry subject. I'm trying to make it more palatable, more trying to inculcate on your. Yes, please.
No, but one thing is for that one who is sure-footed on the charge framing, he can actually build on those submissions. What we say that if the foundation falls, the building falls automatically. If one can develop on that, that is a nuance to structure himself in the field of law as such. So if one can understand that nuances.
Yes, the defense lawyer should be thorough on chapter 17 regarding the framing of charge. If he is very wise, very intelligent, he can get out of the court charge by saying that it's a vague court charge. I cannot be. I will suffer a prejudice if I am called upon to answer this charge. For that reason itself, and if it is a incurable illegality, there is no question of curing it by resort to section 465 CrPC. You cannot resort to 465. It is an incurable illegality. In fact, a distinction was drawn by the Privy Council in Subramania here and in the subsequent ruling also, that irregularity and illegality. If it is an irregularity in the procedure, it is a curable lapse. But if it is an illegality, they put it on a higher pedestal. If it is an illegality, it is not curable by resort to 465, 460, 461, etc. Yes.
Even in civil law, sir, we say that that Marathawada judgment, which says that the vice chancellor's authority was bad, the subsequent ratification by the board of director will not do it, because once the foundation is weak, the superstructure falls.
Correct. In the civil law, in the case of minors, a contract by a minor is void. Therefore, there is no question of minor ratifying the contract. If it is void, if it is null and void, non-est, a contract by a minor is non-est. If it is non-est, there is no question of minor ratifying a non-est. He cannot ratify a non-est. Yes.
It is as good as what we say, anything multiplied by 0 would be 0.
Correct.
Section 214, words in a charge taken in sense of law under which offense is punishable. In every charge, words used as describing an offense shall be deemed to have been used in the sense attached to them, respectively by the law under which such offense is punishable.
Yes. We will understand the question by the provision by answering question number 1.
Yeah. In a case where the prosecution allegation is that 6 members of an unlawful assembly criminally trespassed into house number 1427/52, Baba Saheb Ambedkar Road, Dadar, Mumbai, during 6 p.m. on 14th of July 20, and committed rioting in the course of which they assaulted the house owner by name Sachin Wagle, PW1, causing grievous hurt to him. How will you frame the court charge?
Once, if you master the art of framing a charge, either by referring to the model charges under form number 32 of the second schedule to CrPC, or by referring to the Ratanlal Dheeraj model charges after every section in the Indian Penal Code. If you are able to master the framing of charge, you learn the principle, all the principles. on these facts, I will try to frame a charge for you. On 14/7/2020, at about 6 p.m., in house number 1427/52, Baba Saheb Ambedkar Road, Dadar, Mumbai, you were member of an unlawful assembly, the common object of which was to commit criminal trespass, rioting, assault, and voluntarily cause grievous hurt to Mr. Sachin Wagle, the house owner, and in prosecution of the common object of the said assembly, you have thereby committed an offence, punishable offence of rioting, punishable under such and such portion. You committed the offence of house trespass, committed under punishable under section such and such section. Then you committed assault and grievous. You voluntarily caused grievous hurt to Mr. Sachin Wagle. Thereby you committed, you were member of an unlawful assembly, section 143. As member of an unlawful assembly, you committed rioting, section 147. Then you committed assault or criminal trespass. You committed house trespass into that house, 448 Indian Penal Code. 353 assault. 353 you committed assault on him. Grievous hurt. 322 read with section 149 because there are 5 or 6 accused persons. You are charging each and every accused person with such a charge. Supposing among the 5 persons, only one of them assaulted this house owner. One of them alone assaulted the house owner. But if the common object of all the persons, all the members, was to assault him, was to commit criminal house trespass, was to cause grievous hurt to him, then even the non-performing accused also can be convicted under these sections because they were all members of an unlawful assembly and they acted in concert. That is the principle of section 149. Now, there's what exactly is an assault? What do you mean by assault? Assault is an offence described under section 351 CrPC. When can it be said that a person is assaulted? In the English common parlance, you said when you say that so and so assaulted so and so, you really mean physical assault, is it not? But in the eye of law, physical assault is not necessary in all cases. There's a beautiful judgment by Justice K.T. Thomas from the Kerala High Court, speaking for a division bench in the Kerala High Court. His Lordship, referring to the contours of section 351, assault, held that when the explanation makes it clear that mere utterance of words does not amount to assault, we are merely calling bad names or I'll kill you. It does not amount to assault. It clarifies that such words, when associated with a gesture, can turn into an assault. Supposing I move towards you, saying that I will kill you, I will strangle you to death. I move towards you. Just saying that I will kill you, it does not amount to an assault. But if I make a move, criminal, I make a move towards you, saying that I will kill you, or I take out a dagger, and with the dagger drawn, I move towards you, make a movement. It can amount to assault, even though physical contact is not established. The beautiful judgment by justice. One of the illustrations given in this section is worth. In fact, according to Lord Goddard, Justice illustration C says, A takes up a stick, saying to Z, I will give you a beating. Here, though the words used by A could not amount to an assault, and though the mere gesture unaccompanied by any other circumstances might not amount to an assault, the gesture explained by the words may amount to an assault. Suppose I will beat you, I will give you a beating. Does not amount to an assault. But coupled with that, if he makes a movement, if he makes a move towards the victim, it can amount to assault. That is what illustration C to section 351 says. According to Lord Goddard, Justice Thomas points out, pointing a gun at a person is an assault. That is AR 1946, Privy Council 20. However, showing a knife or chopper by itself may not amount to an assault in all situations. But if the person conveying the threat that hurt would be caused with it, such gesture would amount to assault. The distance between the aggressor and the target may have a bearing on the question whether the gesture amounted to assault. No precise yardstick can be provided in such situation. The weapon used, the background, the degree of the thirst to attack, the words spoken, all will contribute towards the conclusion that he actually assaulted the person. Each gesture by itself may not amount to assault, but all of them taken together can amount to assault, notwithstanding the fact that physical contact is not established. Matthew versus State of Kerala, 1992, Volume 2, KLT 413, corresponding to 1993 Criminal Law Journal 213. 1993 Criminal Law Journal 213. With that, let us conclude today's articulation on sections 212 to 214. Next lecture, we will consider a very important section, 215. Errors, omissions, and etc. in the whether there is a mistake in the charge or error in the charge. How far it is fatal? How far it is fatal to the prosecution? Very important section. We will discuss a few problems, few questions also under section 215 in the next webinar.
Azad says, in a case under section 504-506 IPC, charge was framed by the judicial magistrate stating date of offense only and not stating particulars of time. Please clarify as to whether the charge framed was correct or framing of such a charge without particulars will prejudice.
It requires, because in what way the criminal intimidation was done, the manner of committing the offense will have to be stated in the court charge itself. Mere quoting the section will not be enough, unlike in the case of murder, rape, etc.
So could you elaborate the meaning of distinct offense?
Distinct offense means two separate offenses. Two separate offenses are distinct offenses. Two distinct offenses. They should be subject of a charge, a head of a charge. One offense will be the subject matter of a head of a charge. Another offense will be the subject matter of another head of charge. And 218 clause 1 will refer to that Naseeb Singh's case by Justice Chandrachud, speaking for a 3-judge bench. Very recent judgment, beautifully explained. 218. There every distinct offense should form the subject matter of a distinct charge, and every charge should be separately tried is the rule. But there are exceptions to section 218, 219, 220, 221, 223, etc. Section 219, 220, 221, 223, etc. are exceptions to this general rule under section 218. We will discuss those sections in the coming lectures.
Yes. You go. So one last question is, in a case summons issued, FIR registered, issued to complainant and investigation officer for forgery of documents in a complaint based on complainants got the registered FIR. Can charges be framed based on such tainted investigation and forgery is attempted?
Court will frame charge, because at the time of framing charge, we already discussed in the first lecture. At the time of framing charge, court is bound to examine the prosecution records only, under whether it is sessions case or warrant trial or session trial. The magistrate or the sessions judge can look into the prosecution records only. The defense or the accused cannot adduce any defense evidence at that stage. He can only say that on the material produced by the prosecution itself, this offense is not made out. That he can, but he cannot adduce any evidence. We have seen it is not permissible for the court to make an elaborate inquiry or a mini trial to find out whether these prosecution allegations are false. The pros and cons of the prosecution records cannot be gone into at that stage. Therefore, court is bound, and in fact, that is why we said prima facie case. We said I gave you several decisions, several citations to say that even the Supreme Court has not been very consistent in interpreting those provisions. In one case, in very many cases, they said prima facie case, but the section says whether there is sufficient ground for proceeding against the accused. That is what the section says. Whether there is sufficient ground for proceeding against the accused, or whether the accused can be prima facie. There's said to see I will read 227 once again for your benefit. Whether there is ground for presuming that the accused has committed the offense. Whether there is ground for presuming that the accused has committed the offense is the section, is what the section says. But the interpreting these provisions, it has been held that there should be a prima facie case, and there should be a mere suspicion is not enough. Strong suspicion should be enough, should be there. All these interpretations are there. With the result, in a way, they are a blessing in disguise. In an appropriate case, the court can discharge the accused, and in another case, on the same fact, court can frame a charge. For you have conflicting decisions of the Supreme Court on the same aspect. In a way, it's a blessing in disguise. It's a boon for the judicial officers, judges. We have seen that. Therefore, at that stage, the court cannot look into the documents, if any, produced by the accused. That he will have his opportunity when he is called upon to enter on his defense. Only at that stage. That stage, court is bound or can look into the prosecution records only. The veracity or otherwise of the prosecution record cannot be canvassed at that stage. Of course, from the material produced by the prosecution itself, supposing it is contradictory, self-contradictory, that can be taken advantage of by the accused. But not, he cannot need evidence to show that this document cannot be accepted, this circumstance cannot be accepted. All those things he cannot.
So the last question: is police bound to file all evidence collected during the investigation in a charge sheet? Is police bound to file all evidence collected during the investigation in the charge sheet?
Ordinarily, yes. If all the offences which are made out against the accused, for which there is materials collected during investigation, they are bound to. They are bound to. They cannot drop any offence unless there is no material collected.
Oh, so he's saying to file all the evidence.
If the prosecution wants a conviction, they will have to adduce evidence.
Yeah, they can't keep it to the closed chest.
No. If the prosecution wants a conviction on each and every section alleged in the police charge, they will have to adduce evidence. Because purpose of investigation is to collect evidence in support of the police charge, of the allegations.
So, thank you, sir, for your insightful session. And those who have missed the earlier 3 parts of Justice Ramkumar series, or for that matter, any of our sessions, they can like, share, and subscribe to the Beyond Law CLC channel. They can watch it. And thank you, sir, once again. We will come up with the part 5 on section 215 CrPC, as Justice Ramkumar said. Everyone stay safe, stay blessed, and we are again enamored by the fact that Justice Ramkumar takes out this time, though he's writing a book, but we still persuade him to squeeze the time out of that, and still he's helping.
These webinars are speed breakers in the preparation of the book.
No. They are the right.
They stand in the way.
Thank you, sir. Thank you.